Okay, there we go. Apologies for those waiting online who are here present. As you see, we've had a little bit of technical difficulty, which means you don't get to see my smiling visage on the internet, which is probably better for all concerned. Welcome to those present. Good to see some good numbers here this morning, and we've got a number of people online. Probably those who are still in bed in their pajamas watching this on their laptops. It's so damn cold. So thank you for those who've come in this morning. Yes, welcome to KJK's seminar webinar. I'm Mark Keane, for those of you who don't know, one of the directors of the firm. There will be a number of us presenting this morning. It's a short, sharp, shiny session. I'm going to touch on the current proposed amendments to the legislation, the Return to Work Act, which has garnered a fair bit of publicity recently. Susanna and Neville will take you through some of the more recent cases of interest at the tribunal. Tilly, our new junior solicitor, is going to talk about some key retention strategies in the post-COVID world. And then I think Tracy and Mel, or just Tracy, are going to touch on something that probably hasn't garnered a lot of attention in the last couple of years, which is the issue of conflict of interest and confidentiality, which is an issue imposed on not only decision makers in the scheme, but employers themselves, of course, claims managers and so on. So welcome to this morning. Because we have got limited time, I will jump into my presentation if we can, other than just giving a very quick plug for all the things that we do. We're obviously known as workers' compensation lawyers. That's our larger public profile, but we certainly, through people like Neville, do a lot of employment relations, heavy vehicle law, work health and safety. Tracy and Neville will touch across those. Susanna does some debt recovery for us, and everyone else pitches in with the workers' comp and everything else that goes with it. So that's us. As I've said, though, they're the matters we'll be touching on today. So going to the amendment bill itself, Madam Button Pusher. So what I'm going to talk about today is the second version of the proposed amendments to the legislation, which were prompted by what's become known as the Creedy and then more particularly the Summerfield decisions. The new government put up some amendments about a month ago, and within about 4 days it them and come up with another set of amendments, which begs the question as to whether they had the second lot in the drawer before they threw the first lot out there to see what their reaction was. And what I've subsequently learned over about 30 plus years of practice is that what we're seeing today as an amendment bill is highly unlikely to actually be what we end up with. This South Australian Parliament over many years has shown an ability to make amendments at 2 o'clock in the morning that they push through when they come to some sort of compromise, thinking that they're going to solve a problem, and they end up then creating years of litigation, which is what a number of people have been commenting about again more recently. So the current proposed amendments were put out just under 2 weeks, 2 weeks ago now, because today was the closing date for submissions, although a number of industry players have been asking for more time. The government's flagged they want this legislation passed next month, but as I said, what we're looking at now and what will get passed in a month's time, who knows? So, as I said, designed primarily to impact on the Summerfield case and the whole issue of combination of impairments. We've got to the stage where you can have multiple impairments over multiple years and multiple causes, all being aggregated for whole person impairment and lump sum compensation purposes. So that's what the Act was, or the amendments are proposed to primarily attack, although there's been a number of other tack-on amendments made, and quite feasibly there might be more as we go through the legislative negotiation process. So some of the changes are of substance, obviously, for things like addressing the Summerfield decision. Some of them are just to tidy up in some of the areas. A couple of definitions have been thrown in. As well, a little bit of managing of integration of the Act across the the provisions. So we've now got something that they're defining as a physical injury, which in typical legal terms means, well, it's something that's not physical. Sorry, it's not psychological, it's not psychiatric, it's physical. Okay, thank you for that. They've introduced the concept of being stabilised as a sort of medical term. Read it as MMI. That issue about where you have gone off to have an operation, let's call it after the 104th week of your entitlement period, but you're not at your 156th week of your entitlement period. There's a case that says you don't get the Section 40 benefits. That anomaly is going to be cured by these amendments. The impairment assessment guidelines, as put out from time to time, while previously they've just been issued in effect by the government, now it's going to go through a more rigorous review of any proposed amendments to the guidelines through a parliamentary process. So much like regulations, if the government proposes changes to the guidelines and they don't get through the scrutiny of Parliament, they don't get through, the same as regulations, which the government can propose and effectively be struck down. Interestingly, they've changed the definition of who's able to give financial advice, and as it now says, simply being qualified to give the advice rather than being competent. Interestingly, that sort of, in a sense, opens up the field. But if you understand the financial services field at the moment, the number of people who are still in that field over the last couple of years is rapidly declining because the obligations on them in a professional sense are so onerous. A lot of professional financial advisors are getting into that field. It's just too hard for them to maintain their registration. I know that from a personal contact of mine. So in as much as they're going to simply people who are qualified, the expectation is that you'll be dealing with a financial advisor who is way more qualified now than anyone who could literally put up a shingle in the old days. The main headline is obviously the figures. In as much as a seriously injured worker now for physical purposes and injuries has to be at 35%, 30% still for psychiatrically injured. I think the rationale being it's harder to get over 30% for the latter than the former. Interim seriously injured worker determinations now to be reviewed yearly. That's going to, I think, change a bit of behaviour because workers' lawyers were looking to try to get people onto serious injury status on an interim basis and then try and avoid any whole person impairment assessment for as long as possible, just in case it didn't get to 30% of people today. So these things are now going to be more particularly reviewed each year, and I suspect that's going to then force the issue of whole person impairments actually being conducted as long as MMI is established. And whether they're going to go right through with the legislation and in fact give an improved ability for compensating authorities to actually push forward with whole person impairment assessments when they believe that the person's an MMI, rather than the worker simply sitting back and waiting till they think they want to have the assessment made, will be something of interest in whether the parliamentary negotiation process changes what the current provisions are, because that would make the thing a lot more workable. If you're going to have interim assessments periodically, then I can't see that they want to have that happen ad infinitum, so that maybe there's an ability for stakeholders to be pressing for a change to that part of the equation. There are obviously some other questions now about the ability, and I can't understand the provision, the concern, but where you are seriously injured, you can now elect to seek a new form of payout, which is not a redemption, but looks like a redemption, when you actually already have the ability to receive a redemption. I can't understand the rationale for the provision, so that's a strange one. Section 56 is going to be amended because of, and if you've been reading the case updates lately, you'll have seen that there's been an issue around when you have a second injury where you've already received a Section 56 payment for the first injury, you then have a latter injury, and whether in that case the reduction provision for your second payment occurs or is able to occur depending on whether your second injury is related to your first or not. And there's been a case about that that has effectively said that whatever your latter injury is, the reduction provision applies. The legislation is proposed to be amended so that only will you have a reduction if your first injury and your second injury are somehow emotionally related, same body part, etc. So that is again another approach to cure what's been coming as an anomaly, so to speak, that the test cases have thrown up. Moving forward. Sorry, yeah. Okay, so transitional provisions, and this is where I think there's going to be some uncertainty. What we understand is the provisions will come in with effect from January next year. The broad rule is going to be if you've had an assessment or not had an assessment under section 22, will determine whether you start falling into or outside of these amendments, so that if you're already determined and assessed as at a particular percentage by then the legislation will apply. That begs the question as to what an assessment is and at what stage you consider that that makes the legislation apply, given that we have so many situations where you get a doctor's report that you think or know is not compliant for many reasons, and therefore you don't think it's a compliant or a valid assessment, but is it an assessment nonetheless for the purposes of the provisions? And that's been something that's really not been addressed in the previous legislation and not yet in the current proposed legislation. When are you held to what the doctor says? Is it when they produce their report or not? Because it can go through a peer review process, it can become the subject of a dispute and go off for an injury, an independent medical assessment under the tribunal rules. When and at what time is it going to apply? That still seems to be uncertain. And I had this discussion with Return to Work SA probably 2 years ago over this issue and said, what if Dr. X, who's well known to get things wrong 90% of the time, produces a report that yet again is wrong, and you're telling us that that's a valid assessment, which is what Return to Work SA were effectively saying. There's the report. Why didn't you determine the claim? Well, because we didn't think it was right. Yeah, but it was an assessment. And then you look at them and go, but you're the same people that go back and use peer reviews or we're using for literally every report and wouldn't act on them until they were. So a bit of a head scratcher, but that's another issue I think that's going to get teased out as we try to apply these provisions. At what point is the report you get going to be one you have to act on? And hopefully that will become clearer. But watch this space. And I think no, we don't have any questions online. So with that in mind, thank you. And look, when we do get a final bill passed by the Parliament, we'll obviously be addressing it in a great deal more detail, so that we then, with our crystal ball, we'll look 3 or 4 years down the track and see how much litigation we need, because if history shows us anything, it'll be plenty. Anyway, thank you.
Good morning, everybody. We've got the task of keeping you awake by discussing some case law. So the right first thing in the morning. Make round for lawyers. First case. Oh, this is nice. So I was a teacher. He's a teacher. In 2011, she had a psychological injury when a nice young child brandished a gun in the classroom, and she quite rightly freaked out and ended up with a slight injury. She did return to work eventually, and only on a part-time basis, of course, still within the Department of Education. The issue arose from her perspective that when she had that aggravation in 2017, having had the original injury in 2011, she was still on weekly payments, which has been close to expiring after 2 years when she transferred to ACT. And her position was, I want my average weekly earnings to be set based on my 2011 original injury, and or as an alternative, the top-up payments that I'm receiving or was receiving under the current Act for part-time work should be classed as some sort of leave rather than payments, and therefore my average weekly earnings should be based on 100% hourly rate rather than the part-time. Normal arguments, sort of flagged previously by the case law, but this went right to the full Supreme Court, and we now have well and truly cemented the law in this respect. And that is, so Section 5.9 is really what she was looking at, and that provides that if your level of earnings are affected by a work injury, very important words, work injury, or a gradual onset injury, then the average weekly earnings need to represent a fair amount, reflective of if the work injury hadn't occurred. So her argument was, well, I didn't have the 2011 injury, I would have been full-time, and that was the work injury. And she also then obviously got that second arm of the argument that the top-up payments should be considered as earnings. While the full Supreme Court pretty much shut it down quite quickly on both of those arguments. Section 5.3 does say that average weekly earnings include annual leave, sick leave, and other leave, which doesn't have any definition. And Section 5.5A of the Act refers to when a worker does perhaps reduce hours, but that's on a voluntary basis. I don't think that's really the issue here because she didn't volunteer to reduce hours as a consequence of her capacity to work. So the Supreme Court said quite clearly the work injury is the injury that you are needing to determine at the time. So in this case, it's the aggravation. She already had the prior injury determined. She received compensation for that. And she then had a claim, because it's a change in capacity. That is the injury that is classed as the work injury. So she can't be. So all you can do is go back to 12 months prior to that, take the average, and that's what the department did, and quite rightly so. And the court also made it very clear that you do not get any element of weekly earnings, including your average weekly earnings, because those weekly payments are not earnings in exchange for your labour, they are purely compensation. So law is settled. Work injury is whatever you're determining at the time, not what happened prior, even if it's an aggravation. And earnings are only those, only wages essentially, and annually or sick leave that may have been taken over that prior to 12 months. We then move on to Harry. Harry deals with a PIA assessment. And I think it stresses the importance of, as Mark was flagging before, not simply accepting a PIA on its face. And as I generally recommend my clients, if there's any doubt at all, have it peer reviewed. In this case, the worker had total knee reconstruction, went off to see our favourite Dr. Tran. Dr. Tran assessed the worker. For civil lottery ball cage, spun the ball and pulled out 31%. That was the 31% in there. And of course, 31% for a TKR is a poor outcome. There's a big difference because if you go back to a reasonable outcome is 20% and a good outcome is 10%, so there's big jumps in TKR assessment. And for some reason, only the workers that see Dr. Tran seem to get a poor result. He wasn't the surgeon. Now, in this case, the surgeon, Dr. Porgidis, actually had notes and reports saying this worker had a good recovery. And the physio said that it was a good recovery as well, and the worker was complaining. So the compensating authority obviously had some concerns about this work. So when they had Dr. Tran's report in front of them, they decided that they couldn't determine based on that, they couldn't trust the findings, believe the worker, and they also didn't think that the worker was MMI in any event. It was went to court. Judge Crawley heard the case and confirmed the compensating authority's suspicions that this worker was not reliable. His affidavit evidence was, as they kindly term it in the tribunal, exaggerated. The word was lying, and he just wasn't a good witness. And that combined with the benefit of having GP notes, Dr. Lord Jesus' notes and his report and physio notes, all combined to produce a compelling case. This work simply for the Dr. Tran's report. And there was no criticism of Dr. Tran's actual assessment methods, but he could not reasonably rely upon the worker's presentation to form his opinion. Therefore, this one was sent off to an IMA for a proper assessment. So I get the lesson there is, and I'm seeing this more and more often, don't necessarily trust the PI report as being 100% accurate. If any query or any concerns, you do have mechanisms and rights to review that before you determine it. And unlike what the worker says, the guy, obviously you've seen Hamilton, he said, I've got one shot, that's it. And that's not the case. So you might have your one shot, but it has to be correctly aimed. Moving on to Mr. Roberts. Mrs. Roberts. She was an Aboriginal education worker in the Department of Education. This is a Section 18 case. She was temporarily in a higher position, so AEW4, she was previously in AEW1, and then during the course of that temporary higher position, she was offered a permanent position as AEW3, but before that commenced, she had a psych injury and went off work. She was off work for some time and ultimately lodged a Section 18 application to return to work, but in this case, in a different department, so not in the Department of Education, different government department, and also in a position that would have resulted in her being promoted. So the tribunal had to consider, obviously, the reasonableness of the position that she was applying for, as to whether Section 18 would be imposed or not. The legal department said, no, this person isn't qualified for that position. And we also have something called the Public Service Act, which is a merit-based act when it comes to promotion and selection. The other issue, and slight hiccup for the worker, is by the time this matter actually got to trial, she was no longer incapacitated for work. So it's now set law. You have to have an incapacity to bring a Section 18. You can't just say, I've had a claim in the past, which is really how workers' solicitors were approaching this previously. I've had a claim because the act was not clear. Therefore, I'm entitled to apply for employment or re-employment by Section 18. That's now settled. No, you have to have some incapacity for work to invoke Section 18. So while she may have had some incapacity when she lodged the application, by the time this matter was dealt with, she didn't. So it's essentially the end of the story for her. The tribunal went on to determine the other issues, though, or make comment on them, and that is that while she was asking for a job that she hadn't done before and wasn't necessarily possessing of the skills, if she was, then promotion is possible via the Section 18 avenue rather than the Public Sector Act, which would not have allowed it. And essentially, they said, look, Return to Work Act would override the Act, the Public Sector Act in this case. And also importantly, the employer that is referenced in section 18 must be the employer that she was employed with. So in this case, she was trying to say, well, the government is the employer. The Trump said, no, that's way too broad. You're employed by a large department, and that is where your 18 application must be directed. You can't just pick and choose. So that has relevance to any of you as larger employers or with associated entities that tend to be able to say, well, lodging an 18 application, it really has to be with exactly the same employer, in the same area. You need to look at the workplace as a whole. You try to say, even if the employer has the benefit of if you place a worker in a new area, we do need to look at ramifications that may cause with other employees. So will that cause disruption? Will there be some productivity issues arising? And obviously, as the worker has dominated the job that they've done before, so extend the benefit if they haven't, and it requires significant training, turns the balance back towards the employer. This gives it ability general. So, Section 18 applications seem to be rising, but on the same token, a lot of them seem to be brought just purely for the attempt to settle and give the worker a bit of money. Certainly found a few of those lately, but I just really haven't had any genuine scope. But it's just losing scope to get rid of them. You get one across the table. Preparation is obviously key, depending on Section 18, and considering what exactly the worker is asking for.
And before we go further, I'm not sure if there's anyone here from the Department for Education or is online to confirm whether Roberts was appealed to the full Supreme Court. So if you're online, perhaps just engage in a bit of chat through Zoom and let us know if that case has been appealed.
And finally, for my section, Suzanne's going to take over the rest of the cases in a sec. Very, very quick update on noise-induced hearing loss claims, our favourites. Probably 80% of claims are coming across the table at the moment. McRae, that was a decision of President Dalton. McRae went along to some unknown audiology provider and obviously obtained a audiogram. They said it was noise-induced hearing loss. By some coincidence, ended up with a particular law firm, and the claim was lodged. Clearly, the real aim of the claim was lump sum compensation rather than hearing aids, but as we know, that's how the claims start. In this case, there were some serial audiograms, one pre-employment, one during, and one post. So that's pretty good. You can rely on those because that shows a progression or no progression of loss. Conversely to what a lot of workers' lawyers argue, in this case, they said the previous audiograms were not reliable, and you have to rely upon the one we did in 2021. Because Regulation 67 has to be followed. Regulation 67 says that purposes of compensation under CAP, an audiogram has to be performed by a qualified audiologist, and the work has to be examined by an ENT specialist. Now, how many times do you get claims across the table? All they've done is send you the audiogram, and that's it. They just said, here, determine. I have pushed back previously about this and convinced a few lawyers that's what they need to actually get the ENT report as well. They don't like that because it costs them money. They've got to sit on that until the dispute's over. But I think this case actually does help in that position, because if the workers are trying to now say that it's not a reliable audiogram unless there's an ENT report to go with it, then why not turn the tables and say, well, that's what you need to do first. The judge agreed anyway that the audiograms could not be relied upon because there was no evidence presented as to the qualifications of the audio, those taking the audiogram, the conditions that they were taken in, and essentially, it may well have been just an in-house audiogram. Some larger employers used to do that at least. So a little bit less there. So if you do have a serial audiogram, see if you can find out who did it and whether the audiologists are around, find out what conditions they were taking, and then that would certainly assist in trying to bolster the value of those. They help. If they don't help, just don't worry about it. Strawbridge, Baxter assessed the worker from 1500 hertz through to 4000. As we know, the standard is 2 to 4000 hertz as for noise-induced hearing loss, unless there's some strenuous circumstances such as massive, serious, ongoing excessive noise, rather than just intermittent exposure. And again, the tribunal found that 2 to 4000 is the standard. So the vary of doctors that, and there's still a few around that will drop down to 1500, even 1000 hertz. Because that's extremely unlikely that the worker would actually have loss of that work. In Murdoch, when we redeem workers, it's often basically a standard clause, and I'm sure yours as well, if you use our precedents, is that you're redeeming everything as at that date, and any other injury arising from employment. Now that's a catch-all, so that the worker doesn't come back, excuse me, for a further claim down the track. And redeeming, of course. Now, what's happened with hearing loss claims is that in the past, workers have, well, the injury I redeemed was my left ankle. I didn't contemplate having hearing loss. I didn't know I had hearing loss. And that's a fair enough argument, right? You can't really redeem an injury that you're aware of. And that's how it's been approached. But in this case, the tribunal surprisingly allowed the redemption agreement to be upheld, but on the basis that the worker did actually have knowledge of their noise-induced hearing loss sometime prior, even up to 10 years prior to redemption. So that's essentially what you need to investigate. If you've got personnel files, if you've had pre-employment audiograms or even during the course of employment before determining a claim, and if you've redeemed it, then you can dig up some evidence like that, then you can essentially argue that no, sorry, you already redeemed that entitlement, so no medical expenses for you. They can still get their lump sum compensation. Hearing aids. And finally, Bosnakis, quite a recent case. Essentially, the worker was employed as an electrician a number of years, about 12 years old. So then he became self-employed. His claim was rejected on the basis that his self-employment exposed him to noise. Now, as we know, self-employment is not employment under the Act, but you can still argue that you can't actually have an accurate noise-induced hearing assessment if the worker's been exposed to noise outside of employment. So that's the case. In this case, the worker only left his actual employer in March 2020. His position was made redundant, so there were no the employer, therefore, rid of the tools and machinery, essentially, this worker was using because there was no longer a job to be done. And it was only in October of that year that they engaged, obviously there was a dispute lodged fairly quickly. They engaged Paul During to do a noise survey, and because the actual machinery wasn't necessarily all there, and he had to make assumptions about what tools were used and how long they were used for, and it was clear that the worker was exaggerating the exposure to noise, and the employer was probably understating the exposure to noise. There was a lot of doubt about what the treatments were. I think Paul made assumptions about that, and in his report was relied upon by the Return to Work's independent expert, and the judge found because the noise survey was not done contemporaneously and it wasn't done with the actual equipment being used, identical equipment, that it couldn't be relied upon, and therefore the independent assessment could be relied. So that's actually very good for a prejudice argument, because often we'll get claims in 20, 30 years down the track. Clearly, the first things that will happen, know what the noise levels were. It's easier if that same job is being done, because you can go and check something working, could have them tested. But in cases where we see it all the time, when the job doesn't even exist anymore, or the machinery is long being replaced with much better and more advanced machinery, quieter, it puts a case like that puts us in a position where we can say, the work's got the notice of proof in those cases anyway, because of the time of the shoot. They have to really be put to proof on the actual noise exposure, because there's no way that we can possibly come up with an accurate assessment. So some promising news as noise-induced hearing loss claims evolve over time. I'll introduce Susanna.
It has to speak. Okay, again. Morning, everyone. The first case I want to talk to you about is the case of Foi Application and UTSA. Fairly recent case. This is a case that involved an agreed set of facts, so the worker wasn't required to give evidence at trial, neither were any of the witnesses, and the facts were as simple as this. The worker was at her desk during work, and she wanted to borrow a ruler from a colleague's desk, which meant that she had to stand up with her chair. As she did, she turned, took a couple of steps, and then her right knee collapsed and gave way. That caused her to fall on her elbow, and she ended up sustaining a right elbow fracture as well as an injured knee. Obviously, she sustained physical injuries during the course of her employment, but the issue before the tribunal was whether employment was a significant contributing factor. And to our surprise somewhat, His Honour Judge Crowley.
And disgust.
Yeah, it was disappointing. He said yes, so making the injuries compensable. Now, if we take a step back, during the trial, the Workers' Council turned his mind to various cases, including the case of Ward. Now, the case of Ward involved a worker who, as part of his employment duties, was required to stand at the front of a boat, counting and sorting fish. And on one occasion, he suffered a seizure, which wasn't caused by employment. But as a result of this, he lapsed into unconsciousness, requiring his workmates to pull him into a safer position. And as they did that, the worker caught his foot in an awkward position and ended up sustaining a fractured ankle. And in that case, it was held that the fractured ankle was compensable. So what Ms. Robinson's counsel was saying is that the case of Ward was faced with the same issues that we were faced here. And the respondent's counsel said, well, no, these were very different circumstances. So the uni's counsel tried to distinguish the case of Ward on its facts by saying, well, there were features of employment in Ward, unlike this case. First of all, the worker in Ward was required to be in a boat wearing the large boots. And also there was that action of his teammates pulling him in, which made the fractured ankle compensable. So what the university was basically arguing is that there was nothing special about Ms. Robinson's workplace in that she could have suffered the same type of injury in a shopping centre or at home. Unfortunately, the employment just happened to be the location where the injury occurred. Of course, Judge Crowley disagreed, and in considering whether or not employment was a significant contributing cause, he held that but for the worker standing up and turning in the course of her duties, there was nothing to suggest that the injury to the knee and elbow would have occurred when and where it did. So this case demonstrates that even the most benign actions, which could have easily occurred anywhere, can be found to be compensable. And that obviously from an employer's perspective is quite concerning. Now, the next case I want to talk to you about is the case of Baker. The case of Baker involved a worker who sustained a compensable right shoulder injury in January 2019. She ended up having 2 surgeries that year, and at some stage her treating surgeon said, look, she might have a need for further surgery or even perhaps a shoulder replacement down the track, but this should be delayed for as long as possible until her pain pretty much becomes unbearable. Fast forward to March 2021, and her surgeon says, look, she has about a maybe 10 to 15% chance that she might require a rotator cuff repair in the next 5 years. So the issue that the tribunal faced was, well, whether the time limitations imposed by Section 3320 should be waived to allow the worker to claim the surgical treatment expenses at a much later stage. And the tribunal held yes, the time limitation should be waived. According to the trial judge, the only thing that the worker was required to prove was that the request for an extension of time was reasonable and appropriate. Surprisingly, there was no requirement to prove that the surgery, or future surgery, I should say, was probable as well. So I guess what you need to note is that the relevant provision, particularly in this case, it's not designed to provide administrative certainty to a compensating authority, but rather, once again, in the workers' favour, it's to provide certainty to them about their future compensation rights to medical expenses. And unfortunately, the tribunal's decisions will continue to reflect that reality. The next case is the case of Yard. This case is interesting in that it involved a clinical nurse in a paediatric unit. In March 2018, there were complaints of misconduct made against her, and of course, the hospital decided to undertake a disciplinary process as a result. And that entailed basically suspension of the worker from employment for a period, placing her on alternative duties, as well as some other stuff, and then they found that there was misconduct and she was issued with a written warning. And the process took approximately 5 months. Then on the 5th of September 2018, the hospital made a decision that she was going to be relocated to a different unit. So she was no longer going to be a clinical nurse in the paediatric unit. She was not having this. She was not happy, went off work and didn't return. 5 days after being told that she was going to be moved to a different unit, she decides to lodge a claim for psychiatric injury. And the date of injury being March 2018, so she basically asserted that her psych injuries resulted from the initial accusations, the investigation process, being mistreated by the hospital, feeling isolated, etc., etc. And the claim was initially rejected, but then during a dispute resolution process at the tribunal, the decision was set aside. Fast forward a couple of years to December 2020, she decides she's going to put in a further claim, but this time with the date of injury of 5th of September 2018. So what she was saying is, I suffered a new injury by way of aggravation when I was told that they were going to move me to a different unit. And so basically her entire argument was, between March 2018 and 5th of September 2018, I had a partial incapacity. And then when they told me that that I was going to be moved to a different unit, I then suffered a total incapacity. So the issue before the tribunal was, well, whether the worker psychiatric injury gave rise to an incapacity in March and continued, or whether she indeed did suffer a new injury by way of aggravation when she was told she was going to be relocated. Thank God, the tribunal got it right, I think. They said, no, it's not a new injury. She's had this incapacity and it's continued since March. The decision to relocate her was part of the continuing process. There was nothing separate from what had occurred since March 2018. Now, the trial judge also highlighted something that's quite important, and that is that it would be difficult for the worker to prove that the decision to relocate her after the finding that they made in terms of her misconduct complaints, that decision to relocate her, wasn't done, wasn't a reasonable action taken in a reasonable manner. There was a further issue that arose after the hearing because the worker wanted to reopen her case. She basically wanted to tender some further documents, which from memory involved a letter from someone and some work capacity certificates, which basically reported a change of date of injury from March 2018 to September 2018. the worker's application for directions was refused because the trial judge said, well, look, these documents, they're not going to advance your case in any material way, and justice of the case didn't require it to be reopened. Whew. The last case I want to talk to you about is the case that I can't really pronounce the worker's name. I'm just going to say Amazon, apologies. This is a case that involved essentially two issues, but one ended up being resolved halfway through the trial. So the first issue being compensability, and the one that I want to talk about mainly today is the breach of mutuality. So in this case, we had a worker who claimed weekly payments and medical expenses for a psych injury that he attributed to some bullying and harassment. Initially, the claim was rejected, and if my memory serves me correctly, partway through the respondent giving its evidence at trial, they found that the worker's claim was compensable. But then the issue of breach of mutuality became the focal point. So during the trial, the respondent was arguing that the weekly payments should be extinguished for a period of 8 months because the worker was overseas without their consent. Now, at trial, the worker acknowledged that he was overseas and it was for a period of 8 months, but his position was, well, I told my solicitor, and I was under the understanding that my solicitor would relay this, would give notice to the claims manager. The reason as to why the worker travelled overseas to India wasn't explored, and it was quite vague, which was a little bit strange, but it was held that the respondent had not proved the necessary facts, specifically that it had been notified of the intention for the worker to travel overseas, and also to prove that they had declined consent. The respondent was criticised because it didn't discharge the evidentiary onus upon it, in that they failed to call the worker's solicitor to answer some questions, and they also should have called the claims manager to answer a couple of questions. Had they done that, perhaps we would have seen a different decision. So this case demonstrates the importance of making inquiries and also identifying all the necessary and relevant witnesses to give evidence at trial. It's also a friendly reminder that decision makers need to be mindful that sometimes the onus is on the decision makers, you lot, to be mindful that on occasions the onus rests with you to prove a state of affairs, not necessarily the worker, and that's definitely the case when it comes to breach of mutuality cases. I am mindful that we're running short on time now, so if anyone has any questions, those in person come see me after the seminar, and those attending online, please just put your questions in the chat box. We'll get to it eventually. Thank you.
And just a quick plug as we move through the screen, obviously those of you present either in person or on the internet, if you're interested in getting on our distribution list for case updates, you can either go onto our website and notify us that way, or just let us know in person. So thank you. Now, Tilly is going to address us on some key retention strategies in the post-COVID world. Tilly, apart from having legal qualifications, also has qualifications in human resources, so she's going to flip us out of workers' comp into something a little different.
Hi everyone, my name's Matilda, but only my mum calls me that, so you can call me Tilly. I started at KJK Legal as a law clerk in January, and now I'm a solicitor with a keen interest in human resource management and particularly employment relations. Today, I'm going to discuss 6 key employment retention strategies for the post-COVID world. And I know you're probably all thinking, not another seminar about COVID, we don't want to hear anymore, we've had enough. And I totally get it, I'm over it as well. But however, today I'm going to talk about what we've learned from COVID and about employee retention, and discuss some strategies to try and help wade through the unpredictable storm that is the post-COVID economy. The first strategy is celebrating and incentivizing loyalty. Employee loyalty is the lifeblood of a successful organization. Research shows that loyal employees will invest more of themselves in their work and the organization. One way I think that we can celebrate and incentivize loyalty amongst employees is by making a point to acknowledge their efforts. One of the most effective and simple ways to acknowledge their efforts is to celebrate and thank those that during the pandemic stepped up, worked hard and persevered despite the many challenges before them. Since the pandemic, employees have expressed the need for recognition and for the role they play in the organisation. Some simple ways to do this is by publishing employee accomplishments in the company newsletter, giving our awards at team meetings, or acknowledging employees on social media. COVID has also provided an opportunity for businesses to rethink their employee benefit strategy, to encourage employees to work hard and keep even in these certain times. Unfortunately, gone are the days where employers can book a food truck to come to the office on a Friday, and this suffices as a benefit. The change in working arrangements has created a need for more widely accessible benefits. As an example, you could start thinking about funding paid memberships for online platforms for eligible employees, such as Sweat, which is a pocket personal trainer, or HelloFresh food delivery service. This is not a paid endorsement, by the way. These services allow employees who work remote or in a hybrid manner to access these benefits and that make life easier from the comfort of their own home. Strategy 2 is providing opportunities for growth. Let's face it, the job market at the moment sees in favour of the worker. When workers can't get support for their professional growth from their employers, they seek it from another employer. COVID has provided a unique opportunity for businesses to identify gaps in the skills and knowledge of employees and invest in education and training. Since the pandemic, tolerance for failure has increased significantly, and employees are more motivated to take risks and learn new skills to help solve problems in the future and better prepare themselves for uncertainty. This change in mindset creates an incredible opportunity for businesses to invest in their individuals for longevity and future success. Another way to upskill and develop employees is through stretch assignments. Stretch assignments are temporary personal projects that simultaneously offer employees the chance to develop new skills while helping the organisation solve a business problem. Stretch assignments are an excellent way to increase employee engagement and encourage growth so employees feel valued and like they're in the driver's seat. It's also a great way to reduce training costs, as stretch assignments are informal and can be completed during the normal workday. Strategy 3 is prioritising culture and work-life balance. Since the pandemic, employees have undoubtedly noticed the undeniable interconnection between work and life. The World Health Organization now recognises burnout as an occupational phenomenon which has increased since the pandemic. Statistics show that 1 in 5 people in the workplace are unable to manage the stress and pressure that comes with their position, and this increases their likelihood of burnout. Burnout post-COVID has found to be not just due to exhaustion and overworking, but because employees have lost sight of the greater purpose of the work they do. When employees lose sight of this purpose, it becomes really hard to retain them. I know it may seem really simple, but reminding employees of the why the organisation exists, what they do, and the way that they help can help re-engage employees. An easy and practical way to do this is by sending out regular emails discussing the achievements of the business and the impacts that has on the greater community. A motivated employee is a loyal employee. Another shift that we've seen since COVID is that employees want their employer to prioritise workplace wellness. It's an age-old tale that healthy and happy employees are motivated and productive. So an easy way to focus on employee wellness is encouraging walking meetings, making lunch breaks mandatory, organising weekly meditation sessions, or subsidising flu vaccines, or organising personal budgeting sessions. Strategy 4 is embracing flexibility. During the statewide lockdowns and the work from home directive, businesses were forced to be flexible because it was the only way to survive. However, now that the world has opened up, it's critical that businesses embrace flexibility. A study conducted by EY found that employee turnover significantly increased when businesses in Australia required employees to come back into the office full-time, and 52% of employees said a lack of flexibility in their work arrangements would affect their decision to stay at the organisation. Offering hybrid work solutions is a way to ensure your business is above this statistic. A study conducted by PwC found that while employees wanted opportunities to continue to work from home now that the world has opened back up, they still weren't fully ready to give up being able to come into the office. This is a perfect example of how hybrid work solutions can help attract new employees and retain the one that you have now. Aside from hybrid work solutions, another way a business can show commitment to offering flexibility to employees is looking into a compressed work week. A compressed work week is where employees work on an alternative schedule, which reduces a normal 5-day work week to fewer days with the same hours. For example, an employee who works 5 days a week, 9 to 5, may choose to work 4 days a week, 8 to 6. The benefits of offering employees the opportunity to rearrange their week and their work schedule includes increased feeling of autonomy and better productivity for employees who value their free time. One industry I have personally seen this alternative schedule work for is hospitality. Hospitality workers often have to work long hours, and rearranging full-time employees' schedules to include longer days but only 4 days a week for full-time employees has proven to increase employee morale and subsequently improve employee retention. However, I understand this model does not align with all industries and businesses. And one thing I would consider before offering this type of scheduling is it's legal under your awards and acts. We would suggest seeking legal advice before making any of these changes. Strategy 5 is recruiting for success. Post-COVID, all businesses should be looking to reimagine their recruitment strategies to increase employee retention and organizational agility. One thing that COVID has taught us is the best solution is often right in front of our noses. And therefore, embracing benefits of internal hiring can both benefit you financially and improve your employee retention. During the pandemic, it's highly likely that your business struggled to hire external talent at the same rates as pre-COVID times, forcing you to fill roles internally. However, what was once a necessity to get by has now become your blueprint to employee retention success. A LinkedIn Insight study found that companies who prioritize internal promotion retained employees twice as much as those who didn't. Another way to recruit successfully for employee retention is creating realistic job previews that discuss the challenges, expectations, benefits, and opportunities that come with the position. Future employees then have the opportunity to determine whether their working style and expectations, especially around their working environment, coming into the office, remote working, align with the organization, and this helps streamline the hiring process and improve employee retention overall. The final strategy is valuing feedback. If there's one thing we've learned from COVID, that's that we don't know everything, and you have to have the ability to pivot, take risks, and value feedback. Embracing an open door policy of management is a key way for employees to feel heard and appreciated in the post-COVID world. An open door policy is one that prides itself on open communication across all levels of the organization. The issue for businesses these days is that managers and leaders often turn to an open door policy too late, when employees are already disgruntled and planning on moving on. If businesses can take this and really listen to what employees have to say and act on this feedback, this can really go a long way. Finally, never underestimate the importance of an exit survey. It may be disappointing that an employee is leaving, but on the flip side, it's also an opportunity for the business to learn and grow. Retaining valued employees in the post-COVID world isn't rocket science. It's taking one or more of the strategies that I've talked about today and sculpting it to suit your business model and your purpose. Today's presentation is just the tip of the iceberg of the type of advice and support that Neville and I can provide to your business through KJK Legal's Employment Relations Service. So please feel free to yell out at any time if you would like any help or find out how we can support you. Thank you.
Very well done for a first effort.
Very nerve-wracking presentation. I don't actually remember, it was so long ago. Sure, I was a lot younger.
Just for those who are personally here in attendance, if you need to get away for anything, please feel free. We are going to run a little over time, as we almost inevitably do.
So we're not, I'm going to be really quick. So I think you've actually got my thing in your handouts anyway. So I'm actually just going to talk about a few things about confidentiality, mainly. Confidentiality and privacy are part of the Return to Work Act. And in the course of your duties, whether you're a self-insured employer or even a registered employer, you will be accessing confidential information. And there are some fairly strict provisions about what you can do with that information and what you can disclose. So the Act has various protections built in to safeguard the confidentiality of that personal information. What is confidential information? Basically, it's anything that's not readily available to the public. So if you're a self-insured employer and you're maintaining a claims file, that's clearly all of that information is confidential. If you're a registered employer, you'll be receiving confidential information from your claims agent about your employee's work cover claim. So, I mean, there's no judicial authority about any of this stuff. We've just taken it from the various pieces of legislation and put it together as more of a practical guide. If in doubt, treat it as confidential. That's the rule. So not only are you bound by the Return to Work Act, some of you also have to deal with freedom of information. So if you're a government employer or local government, you're bound by FOI and you will receive from time to time FOI applications from people. And there are some differences between an FOI application and an application under Section 180 of the Return to Work Act. Both enable access to information held by you. So we've put a table up here just to show you the differences between them. There's a difference in response time. FOI is 30 days, Section 180 requests are 45. There are a couple of exemptions under the Return to Work Act as to what you don't have to provide, particularly material regarding investigation of suspected dishonesty, i.e. film. So if you've got film of a worker and obviously the accompanying reports, you don't have to disclose that. You don't have to disclose any legal advice you've received, so anything protected by legal professional privilege. Under FOI, there is some other exemptions as well. I'm not going to worry too much about FOI because that only applies to a few of you. Under Section 180, any worker has the right to access their claims file, and that is something you who are self-insured employers are going to have to deal with when you receive a request. The injury management standards also encapsulate the requirement at clause 2.1.6. You've got 45 days to respond. There are some rights of review. I'm not going to go into them, particularly because I've never seen anyone actually try and review a response to a Section 180 request. But maybe you have seen it, but there are some rights of review. There are also rights of review under the FOI Act as well. Now, the thing that I want to talk about is when you're dealing with the confidential information, how does that work in a practical sense when you are maintaining a claims file, or if you're a registered employee, you're getting information in from your claims agent about your injured worker? Who can you disclose that information to internally? The Act doesn't actually say. No one's got any idea as to what you're actually meant to do. And it shows the difficulty of trying to apply a broad legislative provision to what happens in the real world, because a lot of complaints that workers make about my confidentiality was breached is that they have a perception, wrongly or rightly in many cases, that everyone in the business knows about their claim or knows about their injury. But how do you, as the employer in the real world, have to manage an injured worker who obviously needs to be kept safe at work? So the person on the production line next to them doesn't give them a hard time as to why they're not lifting every box that comes down the production line, because that box is in excess of their lifting restrictions. So there's this real tension as to how you deal with that in the real world, particularly in larger organisations where you've got management structures, you've got supervisors, you've got your injured worker and their colleagues. Who gets to know what's actually happening for that worker, and how do you manage a safe return to work? So there's a real issue about that, as I see it, where the Act says, oh, you know, you're the employer. So who's that? Is that you, the person managing the claims file? Is that their supervisor? Is that the managing director? Is that the board? Is that all the colleagues? I mean, there's no actual definitions of any of this in the Act. So I think you have to look at it from a practical perspective of, if, you know, particularly in a return to work situation, if you're managing a return to work for an injured worker, you need to disclose a certain amount of information, but you have to protect that injured worker's confidentiality at the same time. But you need to take care of them. So it is possible and appropriate to disclose information, in my view, to the supervisor who's going to manage the return to work process on the shop floor, and possibly maybe a limited group of co-workers who are hopefully going to be there to support the injured worker in the process, but not everyone in the business needs to know. And I had a query a few months back from a client who rang me to say that a new manager of a department, obviously quite a large employer, wanted to see the investigation report. It was a stress claim. So there'd obviously been statements taken from various people about why and how and who said what and who did what to cause the worker to suffer a psychiatric injury claim. And this new manager wanted a copy of the investigation report and all the statements to read. And my question was, well, why? Like, why do they need to know exactly who said what to who on what day, you know, 6 months ago? And they're like, oh, well, they just want to know. I'm like, well, what purpose does that serve? Is it, you know, somehow going to help them manage a return to work process? Is there, are they just being nosy? And the person said, I think they're just being nosy. I said, well, say no, because there's some strict provisions about confidentiality. And the client was really happy. He goes, well, that's actually what I wanted to know, because his gut feeling was, this is not right. I don't think I should be doing this, but he's getting a request from a manager, and he's the person, you know, managing the claim for this information. So, you know, there are these practical issues that employers have to deal with in a situation where none of this has ever been, you know, judicially dealt with. So I think you have to use your gut basically and work out, well, what is an appropriate level of disclosure of information about an injured worker to people within the business, but limiting it to the fact that confidentiality does apply. And we know that injured workers don't necessarily want their personal business disclosed to everyone within the business. So, you know, to a large extent, a lot of this is, you know, using your discretion. Now we've got a list of all the various areas where you can disclose information. Again, no judicial interpretation. I mean, a disclosure in the course of official duties doesn't mean anything, frankly. Every time you as a claims person does something, you're doing something in the course of your official duties. I wouldn't suggest that you use that as the excuse for disclosing to everyone in the business everything about a particular claim. Again, I think you need to use discretion and always, in my view, err on the side of caution. The less disclosure that you give, the better, within the limits of, I expect you will have managers who you have to report to, and, you know, those of you who are in private businesses have boards that want to know, well, how much is workers' comp costing us, and, you know, what is the information you have to provide. So, I mean, there's a whole heap of disclosures that are in fact allowed, but again, I would limit it as much as possible in all of those various forms of disclosure that the Act actually allows for. These are some technical issues about disclosure of information to government bodies other than yourselves, and what that is really. Keep going. I'm going to skip over a lot of it so people can get going. Section 186 has specific obligations for employers. I mean, those of you who are self-insured employers have both the obligations to internal claims management, also obligations as an employer. But this also applies specifically to a registered employer. So again, if you are a registered employer, be mindful of what you can and can't disclose. in terms of an injured worker's personal and medical information. I mean, the other thing with medical information is it is also protected by the national privacy principles. So that's a federal government scheme. It's considered to be sensitive information, and there are obligations under that legislation as well. And you can be, complaints can be made to the Privacy Commissioner if a worker considers that their personal medical information has been disclosed in contravention of those principles. So again, that's another layer that you have to think about, particularly for private employers who are covered by those principles. Finally, we've got some recommendations as to how to protect confidentiality and what to think about. And it's as simple as what is the nature of the information? Is it confidential? I think any information on a claims file would definitely be considered to be confidential. Are there times where you have to disclose the information, but can you de-identify the identity of the injured worker or workers? That's more about statistical information, or those of you who obviously as self-insured employers have to report back to Return to Work SA, and ensuring that any data that you share is properly encrypted. I have a couple of clients now who encrypt all the information that they send, even to me. Can get a bit frustrating to remember that every time I get a document, I have to remember to put a code in to access the information. I was like, any technology in me is just never going to work. So I'm like, oh, what's the password again? Every document. Here we go. You know, I'm your lawyer and it's confidential. It's just an automatic system that they have now. So for whatever information they provide is automatically encrypted. So I guess that's the way of the future, particularly, you know, a lot of you and probably most of you now are running electronic files. So it is an issue. It's an issue when the code doesn't work too, but anyway, moving along. I told you we're going to do this very quickly so you can all go. Quickly, I'm just going to do, there's some key takeaways. Again, all of this is in your paper. Start over the conflict of interest. Just going to quickly talk about conflict of interest. It's not something people talk about very much. It can arise quite surprisingly in, you know, the sort of work that you guys do, particularly if you receive a staff claim, a claim by someone you work with. For those of you who are claims managers, I do a lot of conflict of interest work for the corporation for their staff claims. But even I, from time to time, have to disclose, well, no, I actually know that person. And not necessarily that I know that person as a friend, it's just I've been around a long time, so I know a lot of people. So it's never appropriate to handle something where you know the person, even if you don't know them that well, or you know you've not dealt with them for a long time. It can put you in a very difficult position to manage a claim or to give advice on a claim for a person that you know or have known in the past or have had some sort of friendship or relationship. So, you know, it can crop up from time to time. It can also crop up in situations where if you're in a position of authority where you're giving out contracts or, you know, disclosing that, you know, the person who runs that surveillance business happens to be your brother-in-law. That potentially is conflict of interest. So, you know, you need to disclose that to your manager so that, you know, there's appropriate processes in place. And I know like Return to Work SA have very specific conflict of interest provisions in place and requirements for their staff and for their contractors, you know, in terms of disclosing potential conflicts of interest. They do arise from time to time in our industry. It's a small industry, so it's actually not hard for it to occur because, you know, people have moved around. Those of us who've been in the industry a long time have moved around. We go from job to job. Some of us do. Most of us, you know, Mark and I didn't, except once. But you know a lot of people, and it's important to be mindful that those sort of friendships that you've established over a long period of time can put you in a position where that is in fact a conflict of interest, and you should be disclosing it to management. And if in doubt, always talk to someone about it. Like, I will always go in and talk to Mark if I think I've got any potential for a conflict of interest to arise, and vice versa, so that we're comfortable about what we're doing, and also comfortable that our clients know that they're getting the sort of impartial advice that they need, that's not in any way tainted by a friendship or a relationship with someone, even if it's someone we haven't seen for a long time or dealt with for a long time. So particularly in this, like I said, this sort of small industry, these conflicts occur from time to time, and the important thing from your perspective is to disclose them to someone more senior to you, and get a ruling on whether or not you're in a conflict of interest or how to manage that, because you can manage conflicts of interest. There's sort of what we call Chinese wall. So I can't handle it, but Mark could, because he doesn't know that person. I don't have anything to do with the file. I don't access the file. There are, procedures in place. And you can do that in your businesses as well. Mark might know X person from the council who's been the person he's dealt with from time to time on claims. Now that person's got a claim. Well, Mark probably shouldn't handle that file, but maybe Kylie can, because she doesn't know that person at all and has never dealt with them, and you put in place those barriers to manage these sorts of issues. So it's just something to think about. Like I said, it arises from time to time. It can arise for service providers. When you're dealing with service providers, they can have conflicts of interest too. And it's important when you're managing your relationships with them that you're also alert to those issues, so that you're confident that you're getting the best advice, and it's always impartial. So again, I've covered most of this in the handout that you've got. We probably don't need to go through some of the specific confidentiality or conflicts of interest issues, but just be alive to it and seek guidance if in any doubt. So that's my quick wrap up. So you can all go. I just wanted to chat.
Thank you, Tracy. There's obviously a lot more on the PowerPoint slides that could be gone through, but I think the takeaway message, sorry, I'll put my microphone on. Thank you, Tracy. As I've said, there are some further slides that Tracy didn't get to that you can look at your leisure. I think the big takeaway message in relation to both confidentiality and conflict of interest is that when in doubt, receive advice before you do. It'll solve a world of pain. Mel is jumping up and down at the back because she is holding up an exit survey for those who are physically present. So we would really love it if you could provide us with some feedback, comments, critiques. We're an open book, so we can take the criticism and never speak to you again. And we have a chat.
Thank you. Just thank you.
If you've got any questions, a couple of us will be staying on, or feel free to ring us, email us afterwards if you've got any.